And I am delighted to introduce today's speaker, Anne Siegel, who is the Legal Director for Disability Rights Florida. Anne has been an advocate for individuals with disabilities for over 20 years. She received her Juris Doctor from Nova Southeastern University, Shepherd Broad Law Center. During law school, Anne was a disability law fellow at the Children First organization and volunteered as a guardian ad litem. For 15 years, she served as a surrogate parent for children in the dependency system within Broward County. She gained substantial legal experience working as a staff attorney in the Education Legal Rights Project of the Children's Advocacy Program at Legal Aid Services of Broward, Inc. That was from April 2001 to January 2009. Her first job after law school was at the Advocacy Center for Persons with Disability, and then in January 2009, she returned to Disability Rights Florida, which was formerly the Advocacy Center. Today, Anne is the Legal Director and Director of the Client Assistance Program at Disability Rights Florida. And without further ado, I am going to turn you over to Anne Siegel.
Good afternoon. So I'm going to today talk about the legal considerations for youth and the age of majority, and the topic is unsupported decision making. So we could advance the slide, please. Next slide. Thank you. So I'm from the Florida's Protection and Advocacy Agency, and real briefly, I'll just let you know that we are federally funded under 9 different federal grants. We are a not-for-profit, and we are not a state agency. We are a private agency. We provide free and confidential legal and advocacy services to individuals with disabilities in the state of Florida. And our offices are in Tallahassee, Fort Lauderdale, Tampa, Gainesville, and we also have satellite offices throughout the state. One of the actually silver lining to our pandemic was we started branching out, and folks started working from home, which has allowed us to be able to cover a very large state, but having people situated throughout the state has helped us. Next slide. So our mission statement at Disability Rights Florida is to advocate, educate, investigate, and litigate to protect and advance the rights, dignity, equal opportunities, self-determination, and choices for all people with disabilities. And that's really the topic of today, is that self-determination piece. Next slide. So our objectives are to define the less restrictive alternative to guardianship known as supported decision-making, describe how supported decision-making works, how it can incorporate other alternatives to guardianship, such as powers of attorney, healthcare surrogate designations. We're going to go over 3 elements that are typically found in a supported decision-making agreement, and just recognize the importance of preserving decision-making rights and promoting self-determination and autonomy when working with youth with special healthcare needs and or disabilities. The next slide. So the transfer of rights. So at the age of 18, we all know that's officially you become an adult, and now you can contract under law. So I remember very vividly when I turned 18, my mother's advice to me was, you are now a legal adult. Please read everything that you are given very carefully and only sign documents that you agree to, or else you could potentially be legally bound. And I know a lot of folks reach out to us very concerned that, you know, their teens are rapidly approaching 18 and they want to help protect their child from potential exploitation and contracting, you know, going out and buying a Lamborghini that they can't afford and things like that. So this topic here is to help give parents some information, and for youth to understand what their rights are as they are transferring and what will happen legally for them. So I did want to share that under the Individuals with Disabilities Education Act, once a young adult turns 18 years of age, all of the rights that had been safeguarded by the parent under Part B of that act now transfer to the child. So all the decision making, all the signing, all the the right to be there, just all moves over. So we highly recommend that you prepare your child for this transfer of rights so that they are able to advocate for themselves and let their voices be heard. So if a student with a disability has reached the age of majority and does not have the ability to provide informed consent with respect to his or her educational program, there are procedures that have been established by statute and may be used by the parent to, next slide, have the student declared incompetent and have an appropriate guardianship established, and that those provisions are under Chapter 744 of the Florida statute. Parent can also have themselves be appointed to represent the educational interests of their student, or another individual could be appointed for that. Or in the alternative, what we're going to get into today is talking about kind of preserving those rights for your child and using supported decision making. So without further ado, we're on to supported decision making. So what is supported decision making, you ask? Great question. So it's a process that we all use to make choices in our lives every day. Everyone needs a little help making decisions. I know that I use supported decision making myself constantly whenever I have to make a big decision. If I'm looking at, do I want to buy this car? I ask other people's opinions. I usually go to trusted friends or family members that are really kind of content experts in this area. What do you think of this car? What have you heard? I, Google and do information. So, I want to make sure that when I'm making a decision, I have all of the information and I use my trusted friends and family members. And that's really part of what supported decision making is all about. It's having an individual that you trust and a set of tools and strategies to gather the information that you need to help support the individual and assisting them in processing and understanding and determining the course of action. Next slide. So supported decision-making can be used as an alternative to guardianship. It is definitely a lesser restrictive alternative, and it can be used with advanced directives. Individuals with disabilities make their own decisions with the assistance and network of trusted family members that help support them in the process. So it's very flexible and it can be changed and to meet the unique needs of that individual. Next slide. So in full disclosure, I'm a big old Marvel nerd. I love superhero stories. And so I thought I could call upon Spider-Man to assist me in this next one, because it is a fundamental freedom to live as independently as possible. And that's something that maybe some of us may take for granted. Every day we make decisions for ourselves. We decide who we want to associate with, where we want to live, where we want to work. Having that, autonomy in making the decisions for our everyday day-to-day life. And that's what we're talking about here. But with that, as Spider-Man will tell you, with great power comes great responsibility to not only yourself, but to community and society. Next slide. So how does supported decision-making factor into Florida law? Well, the legislature has found that adjudicating a person totally incapacitated and in need of guardian deprives such a person of all of her civil and legal rights, and that such deprivation may be unnecessary. So what we're talking about here is that the courts and at Disability Rights Florida, we're always looking to make available the least restrictive form of any type of guardianship. So we are very pro supported decision making. We feel that taking rights away from somebody should only be done on extreme cases. And really, there are lots of ways to support folks with disabilities who are very capable of making their own decisions, but may need just a little assistance from a trusted friend or family member. Next slide. So why would I use supported decision making? Well, as I use it, because sometimes I have trouble making decisions. You know, I'm always second guessing. Am I making the right choice? Is this what I should have done? Or Monday morning quarterbacking myself. Did I do the right thing? I should have done this. You know, we all know hindsight is 20/20. And so having this support means that you'll be making decisions for yourself, but with the help and assistance of somebody. And that's really the important part of supported decision making. It's not granting somebody the authority to make decisions for you. It's getting a group of individuals who you can rely on to help give you the information and help guide you in the right ways. So supporters can help in many different ways. They can collect and communicate with you information. Like if I'm going to talk about cars, I'm going to ask my brother. My brother has been a mechanic, knows the ins and outs of cars, and I always trust him when I'm looking at making a car purchase. For years, he's always graciously come out and looked at the car and helped me make those types of decisions. They help you explain, understand, and explore your different options, what the risks and benefits are. I know some of us may still be making those pros and cons lists, and somebody can assist you with that, giving you guidance and recommendation, and really assisting you in communicating and carrying out what your decision is. Next slide. So supported decision-making is a process in which individuals with intellectual, developmental, or psychiatric disabilities are assisted in making decisions for themselves. It happens when the individual with a disability is the decision maker. As I said, that is really the important part of this. And when I talk about other supporting documents, it's always keeping in mind that these are driven by the individual themselves. So it's not me substituting my judgment and what I think is best. And I know I am a mom of 2 daughters, and it is a very hard thing for me to kind of step back and let them make their decisions. When they ask me my advice, I am thrilled to give it, but I always have to remember that it's my advice and that I am not the final decision maker. It is up to us. So there's kind of there's not a one size fits all model for supported decision making. It really is based on the individual needs of that person. Thanks. So in Florida, we've had one court has found supported decision-making agreements to be a powerful alternative to guardianship. And that was a case of an individual named Michael Lincoln. We have his information on our website, but he was a young man with a developmental disability who was very active in his community. He participated in volunteer activities. He volunteered at hospitals, went to church, loved movies. But back in 2014, a professional guardian filed a petition to find him incapacitated. And so, though the law requires us to always consider lesser restrictive alternatives, the court in this situation took away Michael's rights and appointed a public guardian for him, which in turn impaired Michael's ability to kind of live his best life. So he wanted to get his independence back, and he reached out to us at Disability Rights Florida, and an amazing attorney in our agency assisted Michael through his fight to regain his rights. And Michael was successful. He has a supported decision-making plan, and he has been able to continue on. He works where he wants to work. He lives where he wants to live. And he is able to make his own decisions. He has a driver's license. He works as a security guard. and he is, out there enjoying and making decisions for himself. And it is just a night and day situation from where you are when you're under a guardianship to where you can be under having a supported decision-making plan. So, the principles underlying decision-making are self-determination, and I'm going to get into that in a little more in depth, but it's person-centered planning. And that is what's so important about supported decision-making plans, is that the individual with the disability is really the person driving those decisions. It's not folks making decisions for them. It's folks giving information and supporting this individual to make decisions on themselves. And I know as a parent, that may sound scary to you, but I know as a youth, you're like, yes, I can do this. Absolutely. And it is just a least restrictive alternative to the different types of guardianships that are out there. So under levels of adulting, self-determination, the supported decision-making circle of support, you can utilize advanced directives, living wills, powers of attorney, healthcare surrogates, banking services, trusts. There may be a representative payee in place, or as you go down, you can see the most restrictive would be a court-imposed guardianship. So this kind of just shows you the range of the different options and what may be best for you as an individual. So self-determination, and I know I've used that term several times, is really the capacity to manage one's own affairs and make one's judgments and provide for themselves. So according to the National Parent Center on Transition and Employment, self-determination is believing you can control your own destiny. Self-determination is a combination of attitudes and abilities that lead people to set goals for themselves and to take that initiative to reach these goals. It's about being in charge, but it's not necessarily the same thing as self-sufficiency or independence. It means you're making your own choices, learning to effectively solve problems, and take control and responsibility of one's own life. Practicing self-determination also means one's experiences of the consequences of making choices. And I know as a parent, I want to bubble wrap my children and make sure that they never have to suffer the consequences of bad choices, but it's really unrealistic. This is the world that they live in, and they really need to be prepared to make these decisions and move forward with their life. Next slide. So it gives you greater control over your own life, the opportunity to make meaningful choices, and the ability to choose from a variety of lifestyles, goals, and preferences. Oftentimes we hear complaints from folks under guardianship about, I can't choose where I live. They won't let me see certain friends. I want to be able to make the same choices as, my non-disabled peers, but I'm always under a microscope and being kind of second guessed. So I can tell you, I fully admit I have made many bad decisions in my life, but I've had the right to do so. And oftentimes, very well-meaning adults, we all want to protect and make sure that our children are not hurt or harmed in any way, and that we want to make things nice and safe for them, but it really is an unrealistic expectation. And then two, I often advise our families, you are not going to live forever. You need to have plans in place to ensure that your child can live as independently as they can live, and with that support. So the ability to live in a least restrictive environment and fully integrated into the community. And that was what was very important for Michael when he came to Disability Rights Florida. So I have a little, what I'm calling a learning activity, but it's just kind of a little demonstration that I wanted to give you to kind of, I always learn best by examples. I mean, I can sit here and drone out Florida statutes, and I do have some of those listed in our presentation, but I will try to give you information that will hopefully not make it so boring, but will stay with you. That's for my learning style, how I've always learned best. So Jane's an 18-year-old woman who is deaf, has autism, and has a seizure disorder. Jane wants to move out of the family home and attend a local state college. Jane's mother thinks Jane should move into a group home for young adults with developmental disabilities who need support services. And Jane has a support coordinator, and the support coordinator also agrees with the family. Jane is on the Agency for Persons with Disabilities waiver and receives Social Security disability insurance. Jane's mother is her representative payee. And some of these terms I'll get into a little later to further explain, but Jane has asked her parents and her support coordinator and her high school guidance counselor, with whom she remains friends, to attend a meeting to make some decisions about what she should do next and how the funding and services she receives should be applied. So the support coordinator gives Jane a list of group homes to choose from. Now, but is that really an example of self-determination? Because Jane has made it very clear that she would like to live on the college campus and have that college experience. Correct. It's not a good example of self-determination. Jane asks the support coordinator and her mother to help her prepare a budget and research the options available for on-campus housing. Is that an example of self-determination? Yes, thank you. It is an excellent example of it, because they are getting her information and giving that information and sharing it to support Jane in making her decisions. So it is all about person-centered planning. The person who the plan affects should be the one leading the planning process. Person-centered planning is decision-driven by the person's wants, needs, and financial abilities. And it's more respectful than decisions made for a person without their input. So I know a lot of you may have heard nothing about us without us. And that is exactly what it is. We should not be making decisions for folks. I understand that we would like to do that and keep everyone safe, but really we are enabling our youth in being able to support themselves and make decisions for themselves of what they really need to do. So we are very, very much a proponent of person-centered planning. So now we're going to go into the tools for supported decision-making. And the first one is healthcare surrogate and living wills. Number one thing, and I will say as an attorney, these can be completed without an attorney. So it's great. It's a form that you can use and fill out yourself. The creation of a healthcare surrogate form and/or a living will is a great opportunity to use in supported decision-making in assisting making the adult's wishes known for healthcare needs or advanced directives. And this is for anyone who's an adult. So this is not just restricted to 18-year-olds. This is later in life. These are opportunities. So the healthcare surrogate form provides for someone to speak on their own behalf in the event she or he is unable to do so. So you clearly lay out what you want in this, and if there comes a time, these documents can be used to support your decisions. Next slide. A living will. A living will is a legal document that expresses a person's wishes regarding the providing, withholding, or withdrawal of lifelong prolonging procedures in the event of a terminal condition, at end-stage condition, or persistent vegetative state. These are known as advanced directives, and a proper living will would allow others wishes for healthcare in the event something happens and you are unable to verbalize what your needs are. So the Florida statute 765-302 Paren 1 provides for procedures for making a living will, as well as the notice to the physician. And then Florida statute 765.303 provides a suggested form for a living will. And as I said, this would only apply to anyone 18 and older. So healthcare surrogate is a legal document that gives permission to another person known as your surrogate to receive the individual health information and make healthcare decisions for that individual. So again, your healthcare surrogate is making your decisions for you because you've already informed them of what you want and how you want things to be handled. So the healthcare surrogate serves in a preparation in the event that you are no longer able to physically or mentally make those informed health decisions. The writing can provide for this authority and take effect immediately or upon legal determination of incapacity. So there are advantages of the healthcare surrogate, and they are, once again, can be completed without an attorney. The creation of a healthcare surrogate form or a living will is a great opportunity to use supported decision-making because, again, with this form, you have the person with the disability has given you their wishes. And so the adult wishes are known for the healthcare needs or the advance directive. And healthcare surrogate forms provide for someone who's unable to speak for, on behalf of themselves. So Florida Statute 765.102 provides that every competent adult has a fundamental right of self-determination regarding decisions pertaining to his or her own health, including the right to choose or refuse medical treatment. And the intent, it was to establish a procedure that allows a person to plan for incapacity by executing a document or orally designating another person to direct the course of his or her health care and receive his or health care information, both upon his or her incapacity. And it's really, I would highly recommend having a written document. I guess that just comes from my lawyer background. I've always said to folks, if it's not in writing, it doesn't exist, but it is a clearer way to show folks this is my intent. It's a less expensive and less restrictive way than a guardianship, and it permits a person previously incapacitated to exercise his full or her full rights to make healthcare decisions, and as soon as capacity to make those decisions has been regained. So the legislature recognizes that some competent adults may want to receive immediate assistance in making healthcare decisions or accessing health information without a determination of incapacity. And in order to ensure the rights and intentions of this person is respected, even after he or she is no longer able to participate in active decision-making concerning himself or herself, this encourages communication among such, for the patient, their family, and their physician. So the legislature declares that the laws of the state recognize the right of a competent adult to make an advance directive instructing his or her physician to provide, withhold, or withdraw life-prolonging procedures, or to designate and to make those someone to help make those healthcare decisions for him or her in the event that they are unable to personally direct their own healthcare. So this is a really important document. And I highly recommend folks have this for themselves. You do not have to be an individual with a disability to benefit from having your directive planned. And so in the event, if something happens to you, unfortunately, your plans, they will know exactly what to do. And it's also a help for your family members because that is an emotional time for them also, to have to try to balance, am I doing the right thing? Am I following, what this person would want? It relieves and takes that pressure away from them. So it's very helpful. So there also are the healthcare facility shall provide each patient a written information concerning their rights, and the healthcare provider may not require a patient to execute an advance directive or to execute a new advance directive using the facility or provider's forms. The patient's advance directives should travel with this patient wherever they go, and a healthcare provider or healthcare facility shall be subject to a professional discipline or revocation of license or certification and a fine of not more than $1,000 per incident, or both, if the healthcare provider or healthcare facility, as a condition of treatment or admission, requires an individual to execute or waive an advance directive. So there's some protections there for the folks that your plan has to be respected and in full force, and that they can't legally withhold care from you, saying it's not on our form or you have to do it this way. So this is just a little bit more going into the department of who oversees that. So we'll just move on to the next slide. And these forms they have suggested forms online. Like I said, Florida Statute 765-203 provides a suggested designation form for healthcare surrogates, and 765-2038 has the suggested designation form for healthcare surrogates for minors. So I did see earlier there was a question, and yes, there are forms that are available online for folks. So advanced directives, that requires capacity. So you cannot have been deemed incapacitated by a court of competent jurisdiction. Advanced directives are like living wills and the healthcare surrogate document that I was previously speaking about. I'm going to jump into a representative payee, and that's really only for folks who are receiving Social Security or SSI benefits. And this is a representative payee, is a person or organization who's appointed as a payee that will receive your Social Security benefits on behalf of the individual and will manage and direct those benefits on their behalf. And this happens when Social Security determines that an adult is unable to manage or make these decisions. So they have somebody appointed for you, or you can choose your representative payee. Oftentimes people have a family member who goes through the clearance, and they are allowed to manage the money and they manage your benefits. But there's also a requirement that there needs to be an annual accounting. And at Disability Rights Florida, we specifically have a team that goes out and conducts these audits to ensure that the beneficiary is benefiting from that money, and that the money is being used appropriately for the care and needs of that individual and not being misspent by a representative payee. Power of attorney is a legal document that gives someone else the power to act in place of another person. So it's a little different than what I've been talking about with supported decision making, because you are actually granting this individual the authority to carry out activities on your behalf. And so it's very important when you choose somebody to be your power of attorney that this is somebody who fully understands and respects your wishes, so that if there comes a time that you're utilizing this power of attorney, that you know that this person is working on your behalf, and because they do have, you know, access to your property in this. So in Florida, a power of attorney must be signed by 2 witnesses and a notary to be considered legally binding. And if a notary does not feel that the person who is the subject of this document has capacity, they can refuse to witness the document. So it's very important that this is something that can be used, but only used for a person who has not been deemed incapacitated. So as I said, powers of attorney give the adult legal authority to act on your behalf. They are not responsible for the actions of debts of the principal. And there's also durable power of attorney, and I will explain that in our next slide. So a durable power of attorney happens if that individual later becomes incapacitated. The power of attorney can be revoked unless the individual has specifically agreed to have this power of attorney continue after a finding of incapacity. So this is also known as a durable power of attorney. And a durable power of attorney is a special kind of power of attorney because it remains intact and durable, even if the person suffers mental incapacity in the future. So a durable power of attorney can, in addition to handling all financial decisions, authorize medical care. And that includes consent to proceed with or terminate all medical and surgical proceedings on your behalf, including in the agreement that falls under, including an agreement that falls under the Life Prolonging Procedures Act of Florida. Again, a durable power of attorney lets someone act on your behalf if you cannot do that because you're incapacitated. So it is very, very important that when you are choosing an individual as your durable power of attorney, that it is somebody you trust and somebody who knows your wishes and will be making those decisions based on what your wants and needs are. Another way to support an individual is also with banking options. Banking services can be utilized to assist an individual with managing money, a joint banking account, or being a co-sponsor on account, and also using online banking for direct deposits and online bill paying are all examples of banking services that can be utilized to assist. And again, with that caveat that if you're giving somebody access to your bank accounts, this should be an individual who is well trusted and you know is working with your best interests. So a trustee holds property and funds for the beneficiary of the trust. It can be the person's own money or given to the trust by a trustee or another. There are special needs trusts designed to prevent assets from impacting receipt of public benefits, such as SSI and Medicaid. I know that some folks have ABLE accounts that allow them to be able to take care of specific needs without that money impacting or being deemed income for their public benefits. Medical proxy, it's also known as healthcare proxy. That's if a person lacks capacity or has DD, the person does not have an advance directive or medical durable power of attorney, and the person needs medical decision making. So an individual, a medical proxy is somebody who can make healthcare decisions for you if you're unable to communicate, and they ensure that your care and treatment preferences are followed. You can provide written instructions on the form itself. Something like, if I am in a coma or unconscious with no hope of recovery, then I want or do not want, and fill in XYZ, whatever your wishes are. There is no financial responsibility for the medical proxy, and this allows this individual to talk with your doctors, consult your medical records, and make decisions about tests and procedures and any other medical treatment that you may need at that time. So why would we need a supported decision-making agreement when we have powers of attorneys and other alternatives? And it really goes to the transference of power. A power of attorney grants another person the authority to make decisions and handle matters really without input from the individual. A supported decision-making agreement does not give that supporter the power to make your decisions. That person with a disability retains the right to make decisions for him or herself, and that is the huge difference between those two, is you are still in the driver's seat guiding that, but when you choose to do a power of attorney, you're removing that power from you and giving it to somebody else who has the ability to make decisions on your behalf. So all of this is clear as mud, right? Capacity is not a fixed concept. A person's ability to make decisions may change over time. It could change with age or an accident or anything. So capacity is not fixed, and also incapacity is not a fixed concept either, because somebody may be deemed incapacitated at this moment in time, but may regain capacity. So there are less restrictive alternatives, and that's always the first option. I do a lot of special education work, and I am always promoting that we need to try the lesser restrictive alternative with supports and services, and then move on to see, but respecting the fact that, you know, a little support does not mean you need all of your rights taken away. So this is the world that we live in, that our children live in. And, you know, we need to prepare them for that. So supporting them and making appropriate decisions on up from when they're little to making bigger decisions as they get older is a really important skill for families to work with. So I do want to let you know, I have some little myths here that these are things that I have been told either by others or in my role as an advocate. And so I kind of like to do a little kind of game here with the myths. First myth, you have to be under a guardianship to continue education after turning 18, and that is incorrect. As I stated earlier, you can continue on, those rights transfer to the child, and that young adult actually is now guiding their decisions, and you can support them in that. Your adult child must be under a guardianship to assist them in advocacy for educational servers. Incorrect. As I said, you can be appointed to represent the educational interests of your child, or you can have another individual who is appropriate to do that, or your child must be, you must place your child under guardianship to assist them in making medical decisions. Again, incorrect. Remember, we've had a very lengthy discussion on healthcare surrogates and medical proxies. I did want to give you a little update just on the education thing. House Bill 19 requires school districts to provide information and instruction to the student and his or her parent on self-determination and the legal rights and responsibilities relating to educational decisions that transfer to the student upon 18. This information must be provided, including access to educational Privacy Act, so it's the Family Educational Rights and Privacy Act FERPA waiver, powers of attorney and guardian advocacy and guardianships. And this went into effect July 1st of this year. So it's very important for folks. Ready? So under Florida statute 1003.57, at least 1 year before your student reaches the age of majority, the school has to instruct the student and the parent on self-determination. It is also a very important part of the individual education plan for students in school under IDEA to be instructed on self-determination so that they are prepared for living once they cross that stage and get that diploma to be as independent as they can possibly be. And this information includes ways in which the student may participate and provide continual participation for their for their parents in educational decision-making, including informed consent to grant access to educational records, powers of attorney, guardian advocacy, and guardianship. And the state board is going to adopt rules to administer this. And so legal rights that can never be taken away. There are some fundamental freedoms and privileges that are protected under civil rights, and these are to be represented by counsel. So somebody under a guardianship who would like that guardianship removed has a right to retain an attorney to do so. They must not be denied access to court. You have a right to a proper education. You have a right to be free from abuse, neglect, or exploitation, the right to receive necessary services and rehabilitation, and the right to be treated humanely with dignity and respect. These are some states that have passed supported decision-making statutes. There are 23 states. The dark blue ones are the ones with statutes. Florida does not have one, although the court did recognize the lesser restrictive alternative. We do not have a statute currently that codifies that into law, but there is a right, for a lesser restrictive alternative when one is looking at guardianship. So we are very busy educating and promoting the use of supported decision-making. And I've just given some resources. You will get a copy of the slides for this. And so there are just some resources here that I find helpful, including our website. We have a lot of information on supported decision-making, the National Resource Center for Supported Decision-Making, Florida Center for Inclusive Communities, and the Florida Association for Centers of Independent Living. And we are here. We want to be able to assist you. And how can we do that? Well, we provide free legal advocacy representation services through our agency, and I put our contact information up there. Ways to go through our intake process is on our website, and then at any of the telephone numbers I have listed on this slide.
And that has been terrific, a wealth of information. Thank you so much. At this point, I am going to both stop sharing the slides and stop the recording. And as I am doing that, I know there have been some questions in the chat. And Linda, would you maybe get us started with some questions?
Sure. And I also want to recognize that Andrea Hickson is here now. Hey, Andrea, if you'd rather